Commissioners, the final item on your agenda will be presented by the Consumer and Governmental Affairs Bureau. It is entitled Rules and Regulations Implementing the Telephone Consumer Protection Act of 1991.
Thank you very much. And another first appearance sitting in the big chair. Allison Culler, we're happy and proud to welcome you as the new chief of CGB and welcome you to your first presentation before the commission, which I think is also your first commission meeting ever.
Correct.
The floor is yours.
Thank you. Good morning, Mr. Chairman, or good afternoon, and commissioners. Today I'm pleased to introduce an item that addresses 21 requests for the commission action on the topic of robocalls, which includes robotexts. Since the law that protects consumers against unwanted calls, the TCPA, was enacted in 1991, the Commission has consistently endeavored to protect consumers without inhibiting legitimate business interests and communications. Despite these efforts, TCPA complaints as a whole are the largest category of consumer complaints we receive, and complaints regarding calls to wireless phone numbers are consistently one of the top consumer concerns. At the same time, petitions filed with the Commission raise questions about the TCPA's application to new technologies and about well-settled, long-standing Commission precedents. The declaratory ruling and order before you provides clarity on an array of issues that consumers and businesses care about most, including what calling equipment triggers the consumer consent requirement and whether consumers can revoke previous consent. And for the first time, the item would clear the path for carriers to offer call blocking technologies to consumers who want to take back control of their phones. The decision before you today faithfully carries out the spirit and letter of the TCPA, sends a clear message that consumers have the right to control the calls and texts that they receive, and recognizes the legitimate interests of the callers. Before turning the presentation over, I would like to thank the other bureaus and offices here at the Commission for their input and collaboration. The Office of General Counsel, the Enforcement Bureau, the Wireline Competition Bureau, the Office of Strategic Planning, and the Public Safety and Homeland Security Bureau. With me at the table are Kurt Schroeder, Chief of CGB's Consumer Policy Division, John Adams, the Deputy of the Division, and Christy Lemoyne, the Attorney Advisor, who will present the item.
Good afternoon, Mr. Chairman and Commissioners. The Telephone Consumer Protection Act, or TCPA, was enacted in 1991 to address unwanted robocalls that invade consumer privacy and pose a risk to public safety. It requires a caller using an automatic telephone dialing system, also called an autodialer, an artificial voice or a pre-recorded voice to obtain prior express consent before making a non-emergency call to a wireless number or emergency lines, among other locations. The TCPA also requires prior express consent for telemarketing calls to residential telephone lines using an artificial or pre-recorded voice. If any of these calls are for telemarketing purposes, consent must be in writing. If not, the consent may be oral or written. The declaratory ruling and order before you resolves 19 petitions for declaratory ruling or exemption, 1 petition for rulemaking, and 1 letter containing a request for clarification. These filings raise several distinct questions. By resolving these questions, the Commission gives consumers more control over the calls they receive and provides callers clarity about the calls they may lawfully make. Specifically, the item clarifies that nothing in the Communications Act or the Commission's rules prohibit carriers or other service providers from implementing consumer-initiated call blocking technologies. As such, wireline and wireless carriers, as well as VoIP providers, are free to provide consumers with services and technologies to block unwanted robocalls. The item also clarifies that the TCPA requires the consent of the actual called party, the subscriber to a phone number, or the customary user of that number, not the intended recipient of the call. Callers will therefore have an incentive to use best practices, such as database checks or email confirmation, to ensure that they're actually calling the person who gave consent and not another person to whom the number has been reassigned. The item finds it reasonable, however, for the caller to have 1 opportunity to call a number to learn whether it has been reassigned before facing liability. The item addresses several other issues regarding consent. It clarifies that consumers who have previously consented to robocalls may revoke that consent at any time and through any reasonable means, that being on an acquaintance's wireless phone contact list is not consent to receive robocalls from providers of third-party applications downloaded by the acquaintance, that consent survives when a phone number is ported from wireline to wireless, and that pre-recorded call setup information provided by collect call services, including inmate call collect services, is not a separate robocall requiring consent. With regard to the TCPA rules that became effective in 2013, the item clarifies that a one-time, on-demand text sent in response to a consumer request do not require separate consent, and grants a limited waiver of the written consent rules so that petitioners may obtain updated consent from consumers who gave written consent under the previous rule. Further, the item affirms the Commission's past interpretations that if dialing equipment has the capacity, even with some modification, to dial random or sequential numbers, it is an auto dialer. As a result, consumer consent is required for voice calls and texts made with an auto dialer, even if the caller is not currently or presently dialing random or sequential phone numbers, but is instead calling a set list of numbers. The item also clarifies several of the TCPA's terms. It clarifies that the term capacity in the definition of auto dialer is not unbounded or so broad as to make any equipment that can dial a number an auto dialer. Addressing a question about who makes a call and is therefore responsible for that call under the TCPA, the item clarifies that an application provider that plays a minimal role in making a call, such as just providing the application itself but not the message content, is not the maker of the call for TCPA purposes. The item reiterates two prior Commission conclusions, that text messages are calls under the TCPA, making auto-dialed text messages subject to the consent requirement, just like any other robocall to a wireless number, and that consumers are equally protected from both telemarketing and informational calls to their wireless numbers if they don't want to receive those calls. The item also clarifies that an internet-to-phone text message, where an email is addressed to a wireless phone number and converted to a text message, is covered by the TCPA. Finally, the item grants exemptions from the TCPA's consumer consent requirement for time-sensitive financial alerts and healthcare-related calls that are free to the consumer. The exemptions are subject to strict conditions to protect consumer privacy, including a prohibition on telemarketing and debt collection content and a requirement that each message provide a way to opt out of future messages. We recommend adoption of this item and request editorial privileges. Thank you.
Thank you very much. Mr. Clyburn.
Today, the Commission responds to 21 petitions by a number of companies and trade organizations for relief and clarification on compliance with the Telephone Consumer Protection Act. Robocalls or pre-recorded messages delivered by a computerized auto dialer, which are covered by the TCPA, are the subject of the highest number of complaints received at this Commission. Our record clearly demonstrates that just as many companies are aggressively using these auto dialers to reach consumers in a lawful manner. Consumer advocates, including members of the legislative branch, are, with equal vigor, expressing concerns about the persistence of high volumes of unwanted communications. I am pleased that this declaratory ruling makes clear that we will maintain the consumer protections the Act intended. I understand that many companies feel that this ruling does not go far enough in delineating exactly how far and within what guidelines a business may communicate with consumers using auto dialer technology. I believe, however, that by reaffirming our broad interpretation of the definition of an auto dialer and by affirming our commitment to congressional intent, we will further incentivize businesses to take the necessary steps to obtain prior consent when it comes to these communications. The Commission is striking a difficult but necessary balance in this item. Over the course of this proceeding, my office has received significant feedback from companies that are trying to reach consumers who gave prior consent to be contacted, but then that very same consent is effectively revoked when the person's number is reassigned. I am sympathetic to the challenges these companies face, since the absence of a comprehensive database of reassigned phone numbers may be an issue. I also appreciate how the Commission has attempted to provide some buffer for companies acting in good faith by allowing them one call post-reassignment in order to affirm any number reassigned. But I would like to see more. I am not going so far as to mandate, however, that any provider participate in the maintenance of a database of reassigned numbers. However, I would encourage voluntary participation by all providers in some type of comprehensive database for reassigned numbers. Another option suggested in the record that might have merit would be that carriers establish a minimum time period before reassigning numbers. Another issue raised is the limited free to end user call exemptions we provide here today in the cases of exigent notifications regarding financial services and healthcare matters. These exemptions ensure that consumers do not suffer dramatic harm to their personal or financial health and security because of the lack of access to timely alerts. Even so, I agree with commenters who are concerned that even these alerts could annoy consumers who have not provided prior consent, so I believe the required immediate opt-out mechanisms and the limited number of calls permitted balance the need for urgent information with the risk of intrusion. Finally, I believe that the decision to provide the clarity requested by 39 state attorneys general is a win. The Commission finds no legal barriers to carriers wishing to offer their customers access to consumer call blocking tools in this ruling, and providing consumers with tools that empower them to take control over the communications they receive is consistent with the intent of TCPA and is exactly the type of offering that we want to encourage carriers to provide. For those concerned that today's decision to affirm the broad application of TCPA may result in consumers losing access to valued communications, I simply say that we will remain vigilant. Consumers have not hesitated to express their concerns about receiving unwanted calls through our complaint process, and I have no doubt that they will do the same if access is unintentionally lost. I would like to thank the staff of the Consumer Government and Governmental Affairs Bureau, I haven't forgotten, for their hard work on this item, and particularly former Bureau Chief Chris Monteith. Your passion and commitment are evident in this particular item. I, of course, welcome our new Bureau Chief, Ms. Allison Cutler, to the team. Thank you.
Thank you, Commissioner. Commissioner Rosenworcel.
Picture this. A family sits down to the dinner table. It's more than an occasion to eat. It's a chance to tell tales of the day and reconnect in a busy world where the demands on our time can feel unrelenting. I know this scene well, because in my household, with 2 parents, 2 jobs, 2 kids, and too little time in the day, the dinner hour is sacred. But all too often, the bliss of this ritual is interrupted by Rachel from Card Member Services, by an announcement that we've been pre-approved for a cruise or a credit card, or by any number of other robocalls presenting us with information we did not ask for, do not want, and do not need. I detest robocalls. I'm not alone. Year in and year out, the Telephone Consumer Protection Act complaints are the largest single category of complaints that consumers lodge with us here at the Commission. We receive thousands of complaints a month about robocalls, and our friends across town at the Federal Trade Commission receive tens of thousands more. at one point receiving nearly 200,000 in a single month. Ugh. It's time, long past time, to do something about this. This is exactly why Congress passed the Telephone Consumer Protection Act, which paved the way for the Do Not Call Act and registry. Like any law, these are not foolproof, but if we update our policies, we can not only give them modern meaning, we can help find new ways to honor our cherished right to be left alone. In some ways, we achieve this lofty goal today, but in others, I think we fall short. First, the good stuff. We bring clarity to the law and empower consumers with tools to avoid unwanted, harassing calls. Specifically, we make clear that nothing in the law prevents phone companies from deploying the latest technologies to block unwanted robocalls. We also make clear that consumers have the right to revoke any prior consent to receive robocalls. So when a consumer no longer wants to receive a company's robocalls, they have the unequivocal right to say stop. These efforts will help consumers manage robocalls, reduce unwanted intrusions, and bring a little more peace to the dinner hour. Next, the imperfect. Consumers have made clear, abundantly clear, they want fewer robocalls. So I do not understand why for some sectors of the economy this commission gives the green light for more robocalls when consumers want a red one. The Telephone Consumer Protection Act is straightforward. It requires a company to get a consumer's prior express consent before making robocalls to their number. But today, we do away with this requirement for big banks, healthcare providers, and pharmaceutical companies. They get a loophole. This order couches this exemption in high-minded rhetoric about informing consumers about upcoming healthcare appointments and threats to their credit. But despite this rhetoric, the result is obvious. Consumers can expect to receive more robocalls from healthcare providers and banking institutions. Moreover, this puts the Commission in the ridiculous business of policing speech made in these calls and itemizing the number of calls permitted by these entities. The same results could be accomplished through private contract. Every one of us knows that. Every one of us signs countless forms to see a doctor or set up a bank account or arrange a loan. Giving our consent on these forms is not only sensible, it would get this agency out of the business of enumerating what calls can be made and what can be said on those calls. Because I think we need fewer robocalls and not more. On this aspect of today's decision, I dissent. Finally, I want to note that we have more work to do. Just last week, the Senate Special Committee on Aging held a hearing about robocalls and scams in which bad actors prey on consumers by faking or spoofing caller ID information. Call spoofing can be a pernicious tactic, confusing consumers who believe they are getting calls from a legitimate government agency or company when in fact it's a scammer on the other end of the line. We need to crack down on this predatory behavior, and if we lack the tools to do so, we need to revise our policies or seek help from Congress for ways to better protect consumers. In addition, we need to give serious consideration to how our robocall policies impact schools. To prevent truancy and create early warning for possible child abduction, many school districts call parents to alert them when students are not in class. But their efforts are getting caught in a web of lawsuits, and the Commission needs to take a hard look at how to fix this. I know this has been a rollicking effort and a contentious proceeding, but in many ways, today's efforts will bring a little more relief from commercial solicitation, a little more quiet in our homes, and a little more peace to the dinner hour. And to the extent it does, today's decision has my support. Thanks.
Thank you, Commissioner, and the points that you made about school alerts and this sort of thing, very well taken. And as you know, we do want to get on with it.
Absolutely. Thank you.
Commissioner Pai.
Congress passed the Telephone Consumer Protection Act, or TCPA, to crack down on intrusive telemarketers and over-the-phone scam artists. The TCPA prohibits telemarketing in violation of our do not call rules. and it prohibits any person from making calls using the tools that telemarketers had at their disposal in 1991. And the TCPA includes a three-prong enforcement mechanism for remedying violations. States, the FCC, and individual consumers can each take illegal telemarketers to court with statutory penalties starting at $500 per violation. Yet problems persist. Last year, the FCC received 96,288 complaints for violations of federal do not call rules, more than any other category of complaints. And just last week, as my colleague Commissioner Rosenworcel pointed out, the Senate Special Committee on Aging held a hearing on ending the epidemic of illegal telemarketing calls. At that hearing, the Attorney General of Missouri testified that the #1 complaint of his constituents is illegal telemarketing. His office alone received more than 52,000 telemarketing complaints in 2014. And the Federal Trade Commission has reported that increasingly fraudsters, who often hide in other countries in an attempt to escape detection and punishment, make robocalls that harass and defraud customers. The FTC noted that a single scam artist made over 8 million deceptive robocalls to Americans. The bottom line is this: far too many Americans are receiving far too many fraudulent telemarketing calls. I know because my family and I get them on our cell phones during the day and on our home phones at night. I have to say, parenthetically though, that I cannot identify with the tableau that Commissioner Rosenworcel sets. In particular, given that I have highly mobile 3- and 1-year-olds, she lost me at "you sit down at the table." But seriously, this problem is, in fact, getting worse. And none of this should be news to the FCC. As I remarked in this very room back in January, unwanted telemarketing calls in violation of the National Do Not Call Registry are on the rise. In fact, such complaints made up almost 40% of consumer complaints in our latest report. And the number of complaints jumped dramatically last year from 19,303 in the first quarter to 34,425 in the third. Let's fix this problem. So fast forward 5 months. What has the Commission done since then to enforce its rules? It has issued a single citation to a single potential violator of federal do not call rules. Almost 100,000 complaints last year, 1 citation. That's not going to solve the problem. The courts haven't been better. The TCPA's private right of action and $500 statutory penalty could incentivize the plaintiff's bar to go after illegal telemarketers, the over-the-phone scam artists, and the foreign fraudsters. But trial lawyers have found legitimate domestic businesses a much more profitable target. As Adonis Hoffman, known to many in these halls, observed earlier this week in the Wall Street Journal, a trial lawyer can collect about $2.4 million per lawsuit by targeting American companies. So it's no surprise that the TCPA has become the poster child for lawsuit abuse, with the number of TCPA cases filed each year skyrocketing from 14 in 2008 to 1,908 in the first 9 months of 2014. Here's just one example. The Los Angeles Lakers offered its fans a fun opportunity. Send a text message to the team, and you might get to place a personalized message on the Jumbotron at the Staples Center. The Lakers acknowledged receipt of each text with a reply text, making clear that not every message would actually appear on the Jumbotron. The trial bar's response? A class action lawsuit claiming that every automated text response was a violation of the TCPA. Here's another case. Taxi Magic, a precursor to Uber, sent confirmatory text messages to customers who called for a cab. Each message indicated the cab's number and when the cab was dispatched to the customer's location. Did customers appreciate the service? I bet they did. But one plaintiff's attorney saw instead an opportunity to profit, and a class action lawsuit swiftly followed. Some lawyers go to ridiculous lengths to generate new TCPA business. They have asked family members, friends, and significant others to download calling, voicemail, and texting apps in order to sue the companies behind each app. Others have bought cheap prepaid wireless phones so they can sue any business that calls them by accident. One man in California even hired staff to log every wrong number call he received, to issue demand letters to purported violators, and to negotiate settlements. Only after he was the lead plaintiff in over 600 lawsuits did the courts finally agree that he was a vexatious litigant. Now, the common thread in each of these cases is that in practice, the TCPA has strayed beyond its original purpose. And the FCC has the power to fix that. We could be taking aggressive enforcement action against those who violate the federal do not call rules. We could be establishing a safe harbor so that carriers could block spoofed calls from overseas without fear of liability. And we could be shutting down the abusive lawsuits by closing the legal loopholes that unscrupulous trial lawyers have exploited to target illegitimate communications between businesses and consumers. Instead, the order takes the opposite tack. Rather than focus on the illegal telemarketing calls that consumers really care about and hate, the order twists the law's words even further to target useful communications between legitimate businesses and their customers. This order will make abuse of the TCPA much, much easier, and the primary beneficiaries will be trial lawyers, not American consumers. Although my written dissent will lay out my objections in more detail, I'll highlight just 3 of the ways that the order makes things worse. First, the order dramatically expands the TCPA's reach. Right now, the Act applies to what we call automatic dialing systems. Think clunky 1980s machines that can automatically dial every 7-digit number. But after this order, each and every smartphone, tablet, VoIP phone, calling app, texting app, pretty much any phone that's not a rotary dial phone will be an automatic telephone dialing system. What does that mean in the real world? It means we're taking our focus off telemarketing fraud and sweeping all kinds of legitimate phone calls within the TCPA. Consider this example. Jim meets Jane at a party. The next day, he wants to follow up on their conversation and ask her out for lunch. He gets her cell phone number from a mutual friend and calls her from his smartphone. Pursuant to the order, Jim has just violated the TCPA, and Jane could sue him for $500 in statutory damages. If he follows up with a text message, that's another $500 violation. Second, the order opens the floodgates to more TCPA litigation against good faith actors. For example, there is no TCPA liability if a caller obtains the prior express consent of the called party. And accordingly, many businesses only call consumers who have given their prior express consent. The problem is that consumers often give up their phone numbers, which are then reassigned to other people. And when that happens, consumers don't preemptively contact every business to whom they have given their number. So even the most well-intentioned and well-informed business will sometimes call a number that's been reassigned to a new person. After all, over 37 million telephone numbers are reassigned each year. And no authoritative database, certainly not one overseen by the FCC, exists to track all the disconnected or reassigned telephone numbers, or to link all consumer names with their telephone numbers. The order makes the situation for good faith actors worse by imposing a strict liability standard. That is, even if a company has no reason to know that it's calling a wrong number, it'll be liable. This will certainly help trial lawyers update their business model for the digital age. Don't take my word for it. Just ask Rubio's, a West Coast restaurateur. Rubio's sends its quality assurance team text messages about food safety issues, such as possible foodborne illnesses, to better ensure the health and safety of Rubio's customers. When one Rubio's employee lost his phone, his wireless carrier reassigned his number to somebody else. Unaware of the reassignment, Rubio's kept sending texts to what it thought was its employee's phone number. The new subscriber never asked Rubio's to stop texting him, at least not until he sued Rubio's in court for nearly $500,000. Third, the order will actually make it harder to enforce our prohibitions on illegal advertising. That's because the order contains a special carve-out for the prison payphone industry. This dispensation lets that industry repeatedly make pre-recorded voice calls to consumers to set up a billing relationship to pay for future services. You might have no interest in receiving phone calls from those behind bars, but prison payphone providers will be able to robocall you anyway. This exemption opens the door to more actual robocalls, the same type of robotic calls that made Rachel from Cardholder Services infamous. Indeed, the rationale provided by the Commission to justify this decision provides a roadmap for those seeking a lawful way to avoid our telemarketing rules. I don't support creating such a loophole. In my view, apart from truly exigent circumstances, the FCC should not condone new robocalls to American consumers, period. Now, there is, of course, much more to the order. Many of the decisions just reiterate well-known, settled law that I support. Yes, the TCPA applies to text messages. Yes, consumers have the right to revoke prior express consent. And yes, a carrier may provide call blocking services with their customers' consent. None of these are surprising outcomes, but none advance the ball. As for the decisions that strike new ground, a few are good law. For instance, app providers won't face a TCPA liability because they don't initiate calls placed by their users. But most of the decisions in this item just shift the burden of compliance away from telemarketers and onto legitimate businesses, sometimes in absurd ways. For instance, how could any retail business possibly comply with the requirement that consumers can revoke consent orally at an in-store bill payment location? Would they have to record and then review every single conversation between customers and employees? Would a harried cashier at McDonald's have to be trained in the nuances of consumer consent for TCPA purposes? The prospect makes one grimace. In all, the order is likely to leave the American consumer, not to mention legitimate American businesses, worse off. That's not something anyone should support, and for all of these reasons, I respectfully dissent.
Commissioner O'Reilly.
Before I begin my formal statement, I thought I would discuss the process used to get to this point on TCPA. I recently ended a conference speech by sharing a core belief. All we really have in life is our good name given to us by our family and our word. After 14 months working on this issue, it is clear that the process brought out a new low that I've never seen in politics or policymaking, which is saying something. Along the way, some of us were led to believe that we were working together to find common resolution. Instead, we were being deceived in order to produce one of the most slanted documents I've ever seen. I will not be so naive to trust again certain people in leadership positions at the Commission. Today's order has been hailed as protecting Americans from harassing robocalls and texts. That is a farce. Instead, the order penalizes businesses and institutions acting in good faith to reach their customers using modern technologies. I'm sure it will be said that we're approving half of the petitions before us, but that's a completely misleading point because many of the petitions were filed due to the belief that the Commission would not do anything to properly address two big issues, reassigned numbers and auto dialers. I've made clear on multiple occasions that I do not condone abusive calling practices. In fact, I've been working for over a year in the hopes of advancing an item that would protect consumers from unwanted communications while enabling legitimate businesses to reach individuals that wish to be contacted. That's the balance that Congress struck when it enacted the Telephone Consumer Protection Act, TCPA, in 1991. Unfortunately, that balance has been turned on its head by prior FCC decisions that expanded the scope of TCPA and through litigation across the country that in many cases has further increased liability for good actors. Indeed, as my colleague has said, it has been reported that over 2,000 TCPA class action lawsuits were filed in 2014 alone. Far from protecting consumers, however, this current state of affairs, where companies must choose between potentially crushing damages under the TCPA or cease providing valuable communications specifically requested by consumers, contravenes Congress's intent for the statute not to interfere with normal, expected, and desired communications that consumers have expressly consented to receive. These include alerts from a school that a child did not arrive at school or that the building is on lockdown, product recall and safety notifications, notifications of utility outages, immunization reminders for unserved or low-income populations, tweets and other social media updates and instant message notifications received by text, updates from airlines to let their consumers know that their flight has been delayed. Moreover, this is despite the evidence in the record of the benefits of informational calls and texts. Indeed, other federal agencies, including the Department of Health and Human Services, have been promoting text messages as a way to benefit Americans. Some agencies even require companies to make certain number of calls to consumers. Additionally, companies may be obligated under state law to contact their consumers. The record also shows that these types of services are popular with consumers as long as they provide timely and relevant information. Supporting examples are provided in my complete written statement. The Commission's unfathomable action today further expands the scope of TCPA and sweeps in a variety of communications, either by denying relief outright or by penalizing companies that dial a number that, unbeknownst to them, has been reassigned to someone else. Indeed, the order paints companies from virtually every sector of the economy as bad actors, even when they are acting in good faith to reach their customers. Incredibly, it even concludes that consumers experience a real harm and a cognizable harm, an intrusion of privacy, by receiving as few as 2 stray calls or texts. To be sure, the FCC narrowly selects calls and texts it thinks consumers should receive and allows them under very limited circumstances. I approve the relief provided to the extent it is granted, but caution that it may not be helpful as some would claim. I'm not even sure it's workable. Otherwise, the decision today will make it much harder for consumers to receive information that they want and need, and will discourage companies from pursuing services that customers may find beneficial. Therefore, I strongly dissent from the remainder of the order. Starting with the threshold issue, I disagree with the premise that TCPA applies to text messages, my colleague had said. The TCPA was enacted in 1991, before the first text message was ever sent. The Commission should have gone back to Congress for clear guidance on this issue, rather than shoehorn a broken regime on a completely different technology. The order also impermissibly expands the statutory definition of an automatic telephone dialing system, or known as an auto dialer, or ATDS, far beyond what the TCPA contemplated. First, the TCPA defines an auto dialer as equipment that has the capacity to perform specific functions. Therefore, it seems obvious that the equipment must have the capacity to function as an auto dialer when the call is made, not at some undefined future point in time. Moreover, the TCPA bars companies from using auto dialers to make any call subject to certain exceptions. This indicates that the equipment must, in fact, be used as an auto dialer to make the calls. Not so, according to the order. Equipment that could conceivably function as an auto dialer in the future counts as an auto dialer today. Indeed, the new definition is so expansive that the FCC has to use a rotary phone as an example of technology that would not be covered because the modifications needed to make it an auto dialer would be too extensive. That is like the FAA regulating vehicles because with enough modifications, cars and trucks could fly. And then using an example of a skateboard of a vehicle that does not meet that definition. Second, the order misreads the statute by including equipment that merely has the capacity to dial from a list of numbers. That's not what the TCPA says. Third, the Commission previously clarified to be considered automatic, an auto dialer must function without human intervention. Therefore, it should be clear that non-de minimis human intervention would disqualify it from being an auto dialer. Fourth, the distinction drawn between different types of apps is without merit. While it is true that different apps may require different levels of engagement by the user before sending messages to the user's contacts, no messages would be sent at all but for the user signing up for the service. Turning to reassigned numbers, every day an estimated 100,000 cell phone numbers are recycled to new users. As a result, numerous companies acting in good faith to contact customers who have consented to receive calls or texts are exposed to liability when it turns out that numbers have been reassigned without their knowledge. Today's order offers companies fake relief instead of a solution, one free pass. That is, if a company makes a single call or text to a number that has been reassigned, the company will not be liable for that single contact. If the call is made to a wrong number, misdialed, there's no free pass at all. Indeed, we may have provided a new way for consumers acting in bad faith to entrap legitimate companies. A person could take a call, never let on that it's the wrong person, and receive subsequent calls solely to trip the liability trap. The idea that after one call, a caller would have the constructive knowledge that a number has been reassigned, even if there was no response, is absolutely ludicrous. The FCC expects callers to divine from mere silence the current status of a telephone number. Think about this in the context of Twitter, which consumers can set to text if anything happens involving them. Before Twitter can even realize the number has been reassigned, they are already liable for hundreds or perhaps thousands of violations. The only solution is to stop the practice entirely. The FCC points to a list of suggestions in the record to help callers determine whether a number has been reassigned, such as checking a number database. Then the item does not provide any relief or a safe harbor for doing so. Moreover, some of the alternatives that the FCC suggests go so far as to be anti-consumer. For example, the FCC notes that companies could require consumers who give consent to notify those companies when they relinquish their numbers. If they do not, the FCC observes that the caller may wish to seek legal remedies for violations of the agreement. In other words, the FCC thinks it's reasonable to have companies sue their own customers. Sadly, there were reasonable options that the Commission rejected. In particular, a number of petitioners and commenters asked the FCC to interpret called party to mean intended recipient. This common sense approach would have allowed a company to reasonably rely on consent obtained for a particular number. The order also decides that TCPA includes a right to revoke consent to receive non-telemarketing calls. But this right appears nowhere in the statute. Instead, the order turns to common law tort principles to read in the statute a right to revoke consent. Talk about bureaucratic activism. As a longtime congressional staffer, I was stunned by this analysis. Usually we start with the premise that a statute says what it means and means what it says. If Congress did not address an issue, then the FCC should not presume to act in its stead. I certainly do not understand why the FCC would resort to common law principles before turning to Congress for guidance or request a statutory fix. Clearly, this is an area where Congress has been active, not just on TCPA generally, but also on the very issue of revocation of consent. The order does grant slight relief in a few limited circumstances and very narrowly, namely to enable consumers to receive fraud alerts, data breach information, medical appointment and refill reminders, hospital registration and discharge information, and home health care instructions. I support the relief to the extent it is provided, but would have gone further. Everyone will soon know that even the relief granted is limited and potentially unworkable. In sum, I am beyond incredibly disappointed in the outcome today. It will lead to more litigation and burdens on legitimate businesses without actually protecting consumers from abusive robocalls made by bad actors. I dissent in part and approve in part for the reasons already discussed.
Thank you, Commissioner. You know, as we've heard multiple times today, robocalls are the #1 complaint that the FCC receives from American consumers. Last year, that number was about 215,000 individuals who took time to write us asking we do something about the annoyance of robocalls. I'm with them. This is a bipartisan issue. Surprise. 39 state attorneys general of both parties have written us saying, will you please do the kinds of things that we're doing today? And why are these rulings necessary? Because technology has outpaced the implementation of the Telephone Consumer Protection Act. When the act was passed in 1991, live people were making cold calls. Today, those calls are made by machines. And that technology has made it cheaper. And as a result, there's been an explosion in the number of calls. An explosion which has been aided by exploiting the wording of our rules to claim a loophole for automatic equipment. Clever lawyers have fed the explosion in robocalls by claiming that if the company substitutes software for hardware to drive the calls and/or doesn't call from a list, that they are exempt from our rules. Today we do what Congress gave us the authority to do. and that is to keep the enforcement of the law up to date with technology, such as text messages, such as automated equipment. Because the loophole that has been exploited heretofore, because we haven't, has fed the expansion of robocalls. It's now closed. Now, make no mistake about it, there are appropriate applications for automatic calling technology, like when the consumer has granted permission or asked to be notified. There's sensible exceptions, as like when the delivery company, package delivery company, notifies you that a package is coming your way when you didn't give permission because you didn't know there was a package. Similarly, your bank should be able to call you about a fraud concern, your doctor about a health emergency. But these legitimate purposes should not be a smokescreen that allows the opening of the door to unwanted calls. There's a simple concept in the statute that we embrace today. You cannot be called unless you consent to be called. The consumer should be in control. Now, the first way that consumers can accomplish this is to tell their phone company to block calls from robocall numbers. The phone companies have resisted doing this because they said the FCC wouldn't allow them to do so. Well, today that issue is cleared up. Phone companies, please start letting your consumers request to have robocalls blocked. We're also instituting a one-strike rule to deal with the way in which mobile phone numbers are frequently reassigned. The new user of a reassigned phone number shouldn't have to put up with being abused by callers for the old user of the phone number. And let me give you an example. We heard from one consumer in that flood of comments that we hear from America. One consumer told us that their phone number, their new phone number, was inundated with 27,809 unsolicited text messages over 17 months, despite repeated requests to stop. That is 27,808 too many annoyances. And it stops today. Now, we've heard a lot about class action lawsuits. If there is a problem in this regard, the proper forum for resolution is the Congress, not the FCC. The Congress explicitly gave consumers a private right of action to sue for those who violate TCPA. I'm amazed that some of my colleagues who usually advocate strict adherence to the statute somehow find flexibility in the law to allow us latitude to favor robocallers over consumers, and to do so in the name of stopping lawsuits expressly authorized by Congress. Congress told us to shut down unwanted calls. Their instructions, including the instructions to keep up with technology, were unambiguous. We will not turn our back on 215,000 Americans who were frustrated enough that they turned to us for help. Listening to Congress and the American people, the message is clear. No unauthorized automated calls. Stop it, and stop it today. I'll now call for the yeas and nays. All in favor, say aye. Aye. Opposed? No. The ayes have it. Are you looking at me, Commissioner? Or?
Yeah, I'm looking at you, but don't worry about it.
Don't worry about it. Okay. Okay. The ayes have it. The item is adopted, and the request for editorial privileges are granted with the objection noted. Would any of my colleagues like to make any announcements at this time, Commissioner?